Wait, please. But so far as the constitutional scheme emerging from the conjoint reading of entry 54 list 1 and entry 23 and 50 of list 2 is concerned, Lord, Mr. Salve has already taken your lordship from Lord Hingir Rampur till Kesavram judgment, my lord, which I will not, my lord, dwell much upon, my lord, except for 10 minutes, just a brief overview. But, my lord, I would.
Yes.
I'm sorry, my lord. But I would like to place before your lordships the government's perspective, my lord, why the architecture of the MMDR Act is the way it is and how it impacts the power of the state versus power of the center. But before I do that, my lord, I want to make one thing very, very clear, my lord. Because the impression, my lord, which is unintentionally gathered is this, that this is kind of a federal issue between center and the state and who has the legislative competence to levy. At the outset, I say, that is not the question here. Right. Lord, here, and as my lord, I will explain, my lord, in a little more detail with some facts, figures, and statistics.
Which volume was it? Yes.
The way, my lord, MMDRA works, and it is intended to work as a limitation, is this, my lord. It is not a fact in dispute that the mineral rights and the ownership of mineral waste with the states, and therefore every penny of royalty goes to the state government. My lord, if your lordship would not like to, my lord, write down, my lord, I have the propositions also, my lord. At the end, my lord, I can give the propositions.
Yes.
But just, my lord, to make it more convenient for your lordship, my lord.
Yes.
My lord, every penny goes. The state government grants the lease. The lease deed format is provided in the central statute.
Yes.
The state government collects the royalty. The royalty figure is fixed by the central government. The state government appropriates that royalty amount with other amounts which I will show as a part of its consolidated fund. Why the center discharges the function of only fixing the rate of royalty qua each mineral? There are several factors, my lord, which I will show, but broadly, to ensure uniformity in the price structure throughout the country,
Yes.
and my lord, our domestic price structure will have to take into consideration two factors. I'm just giving a broad overview. One, the domestic requirement. Which can only be decided at the central level. And second, since the royalty has a direct nexus with the price of each mineral, we will have to be very, very careful and conscious about the global market qua that mineral. if that mineral is cheaper somewhere else, people would start importing, Indian domestic users, and vice versa. So it directly impacts the import export. I may not go into the details. But next and the most important thing, but as I would show, my lord, from one report, which is report prepared, my lord, every 3 years. Your lordships are aware, Section 9 provides that the royalty will, the rates of royalty would be changed every 3 years. So, my lord, there is a report prepared. My lord, it was really heartening to know
Yes.
a classic example of cooperative and collaborative federalism. So what the central government does, your lordship did not write, but in my note, your lordship would find everything. We call for the views from all stakeholders. Stakeholders would mean industries, stakeholder would mean people who are going to be affected by the industries, because ultimately we have to protect the environment as well, and essentially and more importantly, the state governments. I'll show, my lord, from the last report of 2019 that the state very effectively involved in the process. They say that this particular mineral, bauxite, please increase it by 2% because this is our revenue generation. These are the reasons why it should be something more. Then, I'm sorry. Then the subgroup, after receiving, my lord, all these detailed inputs, examines what are the global scenario, what will be the impact on the export-import. But all these minerals are required for the core industrial sector of the domestic market. That is taken into consideration. The core industrial sector is the heartbeat of any economy. So that is considered, and I will show that to your lordships. And thereafter, with reasons why the state's request is either accepted or not accepted, my lord, a price is fixed qua each mineral, and thereafter the central government is out of it. Now you collect, you appropriate, you do whatever welfare activities you want to do in your state. The only dispute between the parties, my lord, in these proceedings is, after having, my lord, it is our case that when we decide the amount of royalty, the figure of royalty, that is all inclusive, taking into consideration all your requirements. What the states say, that over and above the royalty, we can independently levy certain amount under various names. What we believe and what, my lord, the Act perceives, the objective of the Act is that and, my lord, whatever I am saying, my lord, I'll be able to make good from, my lord, the record. So suppose iron ore or bauxite, some amount is fixed, say 100 rupee per ton or per whatever, my lord, there are, my lord, pit's mouth value, etc. That also was argued, but I'll show that's not relevant for this purpose. So the amount comes to say 1,000 per ton, giving a absolutely hypothetical example. They say that every state will have a power to levy something more than 100, more than 1,000. We say no, it is all inclusive, and the reason is this: if every state start imposing further levy, in some case it would be 1,500 per ton. In some case, it would be only 1,000 per ton. In some state, it would be 1,100 per ton. The uniformity of the prices will not be maintained. And I want to flag, my lord, that issue before, my lord, I take your lordships to this, my lord.
Mr. Solicitor, as you are formulating your thoughts, and you have given the example of bauxite, and you say that this rate that is determined, and you said that this is done after elaborate consultation with the stakeholders, including state. And then you say the state is trying to extract over and above the all-inclusive price which you are suggesting to us.
Correct.
Now, taking a cue from the example of bauxite, have you not boxed in the state so far as exercise of their power under 50, entry 50 list 2?
I could not understand the last.
You see, I have said that we have boxed in
everything.
So, where does the state have the power to exercise under entry 50, their power of tax?
That's my lord, respectful submission that the entire architecture of MMRDA, under which this box price inclusive of everything is fixed, is a limitation on the state's legislative power under 50.
But it's totally denuded, you see.
That's my respectful submission.
No, correct.
But otherwise, I'll just give an example, my lord, why this creates a problem.
Why should the, I mean, just asking, of course, you are just at the starting point.
Yes, my lord.
Why should the act, the statute, not say that this is what the tax that the union is charging, and to this extent the power is denuded or something to that effect? Why are we asked to read this by inference?
Lord, my lord, legal submission would be different, my lord.
We also have the situation of, I mean, I was just discussing Article 265.
By merely fixing the road.
That's one which will be forthcoming.
It is there. It is there, my lord. It's invalid text, my lord. Invalid. It would be unconstitutional. But Lord, I'll be able to show that there is an inbuilt statutory mechanism which says that this amount and nothing more. Otherwise, my lord, what happens? Just give. Of course, example would not, my lord, be the basis for your lordships to decide. But I'm just giving an example, the rationale why, my lord, this is under the central control, the fixation. Lord, suppose there are two states, A and B. A has, my lord, an electricity generation station of a huge capacity. They are using coal as a raw material. B has raw material mines, my lord, namely the coal mines. They say that over and above 1,000 rupee, which is the royalty fixed by the central government. I'll give examples. In many states, India segments, other cess, education cess, different nomenclature, was 300% royalty, 500% royalty, etc., etc. So that state A having the electricity generation plant will have to either pay more from state B, because every state has a different price structures.
But Mr. Solicitor, that is implicit in a federal scheme. You see, therefore, unless you say that, look, when you fix, as you call it, an all-inclusive royalty, that royalty includes all taxes also that can be levied by the state. You have to go as far as to establish that.
Correct, Manoj.
That the fixation of royalty is itself inclusive of all taxes, state
and nothing
taxes.
more.
That's one. Second, your argument that, well, it's desirable that there should be uniformity of the price of minerals. It may be a desirable matter as a matter of policy. Question is whether this will impinge upon the federal distribution of power under the Constitution. Now take another case. Look at, there's several taxes the states can levy under the state list.
My lords.
I'll just give you two examples. Entry 53 of list 2, taxes on the consumption or sale of electricity, right? Now, in various industries, electricity is not just a medium, but it's a raw material. For instance, in the production of steel, iron and steel industry, electricity itself is a raw material.
Yeah.
You know,
It's part
Now,
of the price
the-
structure also.
Right. And now the Constitution contemplates that each individual state can levy a tax on the consumption and sale of electricity. Now, different states levying taxes at a different rate on the consumption and sale of electricity will meet with the same argument that you are urging, that in Maharashtra may impose it at a different rate, Karnataka may do it at a different rate, a solar plant in Rajasthan may do it at a different rate. But that's part of the federal scheme. Or take entry 54.
Right.
Taxes on sale of petroleum crude, high-speed diesel. High-speed diesel is crucial for industry. Motor spirit, natural gas. So if you are consuming natural gas from, say, which comes in from Jamnagar, different rate altogether. If you are importing natural gas, which has come in through, say, a crude pipeline, a gas pipeline, say, in Chennai, completely different rate. That's exactly the scheme of the Constitution. That and there is nothing sui generis about minerals, that there should be a uniformity. Then the same logic will apply to electricity. Have the same rate of electricity, same taxes for electricity.
Ignore that example and I'll give the answer. I'll give the answer. In other entries like electricity or entry 54 list 2, there is no provision like entry 50 that's subject to limitations placed by the parliament under 54.
But therefore, there is a safeguard. Suppose, say, Jharkhand places taxes at the rate of 500%.
Ignore that example. I'll make it good on other issues.
Suppose some state levies rates at the rate of, say, 300%, something disproportionate, which will really affect the industry. And that state is a primary source of that mineral in India. Parliament can certainly regulate the rates. When you are prescribing limitations, you can say that, look, rates will not exceed so and so. Rates on this mineral will not exceed so and so. You can have differing limitations for differing minerals.
So please ignore that example for the time being.
Union has not thought through how they can use the limitation power, imposing power, to ensure that whether states are not restricted in imposing taxes, the taxation structure in the states does not affect overall the development of the mineral or the development of the industry. Parliament can still do it. But they'll have to do it then in a nuanced case by case, mineral by mineral basis.
That is where, we would respectfully, argue that MMRDA is that restriction. What is the Constitution says limitation on? Well, this is sui generis for the simple reason. This is the only entry, taxing entry, which is made subject to some other entry. There is no other taxing entry. Number one. Number two. In
but
case
it's not
of
made subject to the other entry, it's made to subject to limitation in the interests of the regulation and development of minerals. So it's quantified very carefully. Mr. Salsara, if you want to sit for a minute, sit.
no.
The limitation is a constitutional limitation. It is not any kind of limitation.
Exactly.
So a constitutional limitation has to be read in the context of Article 265 of the
And
Constitution.
that too in public interest.
Because there can be no taxation except
Correct.
with authority of law. So a constitutional limitation to tax juxtaposed with Article 265 must be the
Correct, Manoj. I bow down.
interpretation.
I bow down. Second, as Manoj,
I think you have to answer. You are banking upon the fact that states have say in determining royalty. There you may not be right. Under section 9 subsection 3, it is the exclusive power of the central government to decide what is the royalty. States have no power, no read section 9 subsection. The exclusive domain of the central government. States do not have any say in fixing royalty.
If your lordships can, consider, allowing me to develop further.
You are just pointing out so that you can answer.
Certainly, I'm conscious of the fact that the consultation is not statutorily contemplated. That's what, my lords, are very rightly putting it to me. But the consultation is read in every provision. That's what I'm going to show. Please take my written submissions, Manoj.
Where do we get them,
Volume 2F. And Manoj, I will ignore whatever is argued or whatever may perhaps not be relevant immediately.
Volume?
2F.
2F.
It should be
2F, Manoj.
E.
No, it is thereafter changed. There was some mistake at night, Manoj.
We should ignore E.
Yes, Manoj. Please ignore it, Manoj. And if possible, delete it, if it is possible to delete it. Annexure was wrong, Manoj. Instead of the report of 2019, The report of 90 was annexed. There was nothing to hide in there, but that was no relevance of that.
Got it, got it.
Page 5, page 4. PDF 5. I'm sorry. PGA PDF 4. I'll, my lord, keep what is not relevant, but what is relevant, please allow me to, my lord, read. My lord, this history relates back to the industrial policy. I'm not reading it. I'll just, I have annexed, my lord. Lord, Lord, historically, Lord, after, immediately, not immediately, but sometime after independence, Lord, we declared our industrial policy, Lord. First was 48 and thereafter 56. I have annexed it for your lordship's reference and record, but I'm not going to read it. Lord, the intention to place this is this, Lord, that the nation for the first time decided how our industrial growth will take place, what would be the roadmap. And there, they divided certain sectors in Schedule A, Schedule B, Schedule C, and Schedule D, where core minerals were placed in Schedule A because they are directly or indirectly responsible for industrial growth of other industries. That's the purpose. Lord, please come to, my lord, PDF 6, my lord. Para 4. PDF 5, my lord, I'm sorry. PDF 5, para 4. I'm sorry. Okay, this is wrong. I'm sorry. My lord, PDF 6, my lord. I am, as usual, my lord, behind the rest. Para 4, my lord. The Industrial Policy Resolution 1956 put major minerals such as coal, lignite, mineral oils, iron ore, copper, zinc, atomic minerals, etc. in Schedule A, which was reserved exclusively for public sector, and minor minerals in Schedule B, which the private sector was allowed to participate in mining activities. Your lordships can, my lord, thereafter come to page 5, para 5. The minerals available in the nation are naturally finite and are perhaps the most valuable resource for the development of the country. Minerals are the vital raw material for the core sectors of the economy. The exploration, extraction, and management of minerals have to be guided by national goals and perspectives to be integrated into an overall strategy of country's economic development. The endeavor shall be to promote domestic industry and reduce import dependency, which make domestic industry resilient and self-sustainable. Well, this is the difference. In other cases like electricity, etc., we don't have to see the global market. There can be, my lord. And please, my lord, for the time being, my lord, allow me to say, please don't treat this as a federal issue. There is no state versus center. It is the state government which collects everything only for the reasons which will follow. The price, the royalty fixation, the quantification is done by the center, keeping the global phenomena and the domestic scenario in mind. Then your lordships may come to, my lord, 7, para 8. This is, my lord, more relevant, my lord, why, to answer, my lord, the Chief Justice of India's query, my lord, why mineral stands on a different footing and why its fixation of everything which is to be extracted from whoever is liable to pay is to be federally governed, my lord, if I may use that expression. 8. The mining sector and extraction of mineral, by the very nature of the subject, requires to be taken up holistically at a national level, as its regulation and development shall have to be based upon the following. My lord, please see each one of them, my lord, carefully. National landscape for protection, exploration, and extraction of mining. Mineral being a national wealth, its distribution for the benefit of every citizen of each state as per principles of socialism enshrined in the preamble. Then 3, impact of high burden of levy on Indian minerals in comparison to international mining jurisprudence. Look, this is crucial. Look, if high burden is put on each mineral, my lord, by different states differently, we may not be able to, my lord, deal with the global situation. But 4 is really, my lord, crucial, according to me. I'm sorry.